Hello students, welcome to AKS IAS. So, as part of our monthly current affairs magazine series, we will be discussing about the analysis of the AKS IAS current affairs magazine of August 2020. So, in this magazine, we will discuss about the various current affairs which have appeared in the month of July 2020 as part of this current affairs magazine. So, we will start with the discussion of polity and governance related current affairs. So, number one, amendments in the Indian Stamp Act. What is the issue about? The amendments in the Indian Stamp Act of 1899 brought through the Finance Act 2019 and rules made thereunder will come into effect from 1st of July 2020. Let us look into the details of this. These amendments to the Act and rules will enable states to collect stamp duty on securities market instruments at one place by one agency, that is through the stock exchange or clearing corporation authorized by it or by the depository on one instrument. So, the basic agenda is one place, one agency, and one instrument. This was done in order to facilitate ease of doing business and to bring uniformity on the stamp duty on securities across the states and thereby build a pan India securities market. A mechanism for appropriately sharing the stamp duty with relevant state governments has also been developed, which is based on the state of domicile of the buyer. What was the need for these amendments? The present system of collection of stamp duty on securities market transactions led to multiple rates for the same instrument, resulting in jurisdictional disputes and multiple incidences of duty, thereby raising the transaction costs in the securities market and hurting the capital formation. So, the potential impact of this amendment will lead to rationalization and harmonization of the system through a centralized collection mechanism, which is expected to ensure minimized cost of collection and enhance the revenue productivity. Further, the system will help to develop equity markets and equity culture across the length and breadth of the country, thus ushering in balanced regional development. The next current affair of importance is no postal ballot facility for voters above 65 years of age, as said by the Election Commission. The Election Commission has said that the postal ballot facility for electors above the age of 65 in the Bihar Assembly elections will not be implemented. The poll body said that the opinion of postal ballots would be available to the electors over the age of 80 years and persons with disabilities, essential service workers, and those infected with COVID 19 or suspected to be. Let us look into the details of this. Until October 2019, the provision of voting through the postal ballot was available to armed forces personnel and those assigned poll duty. In October 2019, however, the Union government accepted the poll panel's recommendation and the law ministries made made amendments by allowing voters who are 80 years of age and above or those with disabilities to use postal ballot for voting during parliamentary and assembly elections. The assembly elections to Bihar's neighboring state Jharkhand held in November December were the first that saw the provision being implemented. What is postal voting? Postal voting is a restricted set of voters who can exercise postal voting. Through this facility, a voter can cast her vote remotely by recording her preference on the ballot paper and sending it back to the election officer before counting. Who can avail this facility? The members of the armed forces like the Army, Navy, Air Force, members of the armed police force of the state, and the government employees posted outside India and their spouses are entitled to vote only by post. In other words, they can't vote in person. Thus, these voters under preventive detention can also the voters who are under preventive detention can also vote only by post. Special voters such as the President of India, Vice President of India, governors, Union Cabinet ministers, speakers of the House, and government officers on poll duty have the option to vote by post. but they have to apply through a prescribed form to avail this facility. Recently, the Law Minister, at the Election Commission's behest, introduced a new category of absentee voters who can now opt for postal voting. These are voters employed in essential services and unable to cast their vote due to their service conditions. Currently, officials of the Delhi Metro Rail Corporation, Northern Railways, and media persons are notified as absentee voters. So that was about postal ballot and the recent decision by the Election Commission. Next is judicial review can't be done prior to Speaker's decision. What is the context of this article? This judgment is significant in the case of the ousted Rajasthan Deputy Chief Minister Sachin Pilot and the 18 MLAs who were issued a notice under the anti defection law after the ruling Congress party sought their disqualification. They have approached the Rajasthan High Court challenging the constitutionality of paragraph 2, clause 1A of the 10th schedule of the Constitution, which makes voluntarily giving up the membership of a political party liable for a disqualification. The constitutional courts cannot judicially review disqualification proceedings under the 10th schedule or the anti defection law until the speaker or the chairman makes a final decision on his discretion based on the merits of the case. So, let us look into the judgment of the court in the Quixoto Holan versus Zachillu and others. So, in this judgment, a 28-year-old judgment of the Supreme Court in the Quixoto Holan case has said that the judicial review cannot be available at a stage prior to the making of a decision by the speaker or the chairman, and a quiatimate action would not be permissible, nor would the interference be permissible at an interlocutory stage of the proceeding. The only exception for an interlocutory interference being cases of interlocutory disqualifications or suspensions, which may have grave, immediate, and irreversible repercussions and consequences, is what the Supreme Court had held regarding the anti defection law in the Quixoto Holan case. What is judicial review? Judicial review can be understood as a form of court proceeding, usually in the administrative court, where the lawfulness of a decision or an action is reviewed by the judiciary. Where there is no effective means of a challenge, judicial review is available. The concern behind judicial review is that whether the law has been correctly applied with and right procedures have been followed or not is the primary concern. Judicial review and the Constitution. According to Article 13, Clause 2 of the Constitution, the Union or the states shall not make any law which takes away or abridges any of the fundamental rights, and any law made in contravention of the aforementioned mandate shall to the extent of contravention be void. Judicial review is called upon to ensure and protect the fundamental rights which are guaranteed in Part 3 of the Constitution. The power of Supreme Court of India to enforce the fundamental rights is derived from Article 32 of the Constitution. This provides citizens the right to directly approach the Supreme Court and to seek remedies against the violation of fundamental rights. Okay? Next, disabled are entitled to same benefits as the SC and ST quota. According to the recent decision of the Supreme Court, the persons with disabilities are entitled to the same benefits of the scheduled caste and scheduled tribe quota. Let us look into the details of the Supreme Court judgment. The Supreme Court, in a significant decision, confirmed that persons with disabilities are socially backward and also economically backward, and thus are entitled to the same benefits of relaxation as the scheduled caste and scheduled tribe candidates in public employment and education. A three-judge bench led by Justice Rohinton Nariman upheld the 2012 judgment of the Delhi High Court in the Anamol Bhandari through his father or national guardian versus the Delhi Technological University case. In the Anamol Bhandari case, the High Court had correctly held that the people suffering from disabilities are also socially backward and therefore, at the very least, entitled to the same benefits as those given to the scheduled caste and scheduled tribe candidates. Thus, the Supreme Court had held that the differently abled people can now be entitled to the same benefits which are enjoyed by the marginalized sections of SCs and STs. Next article that is mentioned in the magazine is regarding to the making of justice accessible through live streaming. So this is regarding making the live the proceedings of the Supreme Court and High Court through live relay so that it is accessible to the people, even in times of COVID-19. So, what is it about? The pandemic has presented Supreme Court with both a challenge as well as an opportunity to adopt technology. As the lockdown began, the court had to quickly find the technology and create protocols for virtual courts and e-hearings. What is the background of this? Before this, the judicial system assumed that physical presence was necessary for justice dispensation. Further, the Indian Supreme Court had maintained that no public record of its own proceedings should be done, nor were its proceedings broadcast live for public viewing. So, the public viewing of the court proceedings was not available until now. Although people were allowed to visit the open courtrooms as part of justice dispensation under the Article 21 of the Constitution, never were these recorded or put in public domain. So, what is the need for live streaming of the court proceedings? Restricted access. Owing to the security constraints, a pass is mandatory for entering the Supreme Court, and due to the spatial constraints, law students can't enter on Monday and Friday. Number two, in the Swampil Tripathi case of 2018, the court recommended proceedings must be live and deemed live proceedings as part of the right to access justice under Article 21 of the Constitution. Further, publishing the proceedings is a duty under Article 129 of the Constitution, as per which the Supreme Court is a court of record. Next, international norms. In many democratic and non democratic countries, constitutional court proceedings are recorded in some form or another. Such as in Australia, they are recorded and posted on the High Court's website. The same is true for Supreme Courts of Canada, England, Brazil, and Germany, where they are broadcasted live. Next important point is it will also augment trust in the judiciary. Live streaming will help citizens understand the nitty gritties of the critical cases which leave a significant impact on the people, like the Ayodhya verdict, Section 377 case, etc. Otherwise, they need to depend on the lawyers for getting some insights on the judicial process. Thus, this strengthens the trust of the masses in the judiciary. Next is ancestral knowledge. The budding lawyers and jurists can learn a lot if they have access to the repositories of cases fought by various stalwart lawyers such as Ram Jetmanali and likewise. What are the steps which have already been taken to improve access to justice? The court started providing vernacular translations of its judgment. Number two, non accredited journalists were permitted to live tweet court proceedings. During the lockdown, journalists have been permitted to view virtual court proceedings in real time. What is the way ahead? The court must expand the right of access to judgment to judge. Sorry, the court must expand the right of access to justice by live streaming proceedings, as technology for the same is readily available today and already tested by journalists. The Supreme Court must take advantage of many modes of communication as possible, including the internet, the social media, television, and radio. This will enable it to reach a wide cross section of the Indian society. Further, the court proceedings must be documented and preserved for posterity. Both the visual as well as audio recordings and the transcripts of oral arguments should be maintained for this purpose. To begin with, constitutional and national importance cases can be live streamed as a pilot project, while cases pertaining to national security can be excluded. It seems that for the next few years, Indian courts too will have to adopt a combination of virtual and in person hearings. The Supreme Court has chosen to play an influential role as an institution of constitutional governance under which public is rightly interested and has a right to know about the proceedings of the court. Okay.